those of you who don't know me, my name is Dr. Cheryl Lawther, and I am the Director of the Human Rights Centre here in the School of Law at Queen's. Today we welcome the Malone House Group to our seminar series. As many of you will know, the Malone House Group are a group of academics, lawyers and other interested parties who are actively engaged on working on the debate on dealing with the past in Northern Ireland, with particular attention to issues of truth and justice. Of course, this is a very difficult and contested area, but it is also one of increasing urgency in terms of being able to deliver truth or justice or acknowledgement or apologies and so forth for those who suffered as a result of the Northern Ireland conflict. Today we have two speakers. We have Dr. Austin Morgan and Neil Faris. Neil will start us off this afternoon, and then we will hand over to Austin for his presentation. Each of our contributors will speak for approximately 15 minutes, and after they've finished their contributions, we have time for question and answer. Just to remind you before we start of the housekeeping rules, could I ask you to mute your microphones and to turn off your cameras, please? Once we get into the question and answer session, please feel free to come in over the audio and video or to use the chat bar to post your questions. So I'll hand over to Neil now, and I look forward to receiving your questions shortly. Thank you.
Yes. Hello, everyone. And thanks to Cheryl and the Centre for this invite. Now, just a few introductory points. Firstly, legacy discussion may still be traumatic for those who have suffered bereavement, injury, or other loss and hurt in the decades of sectarian terrorism. Perhaps indeed some participating in this webinar have so suffered and are continuing to suffer, or may have close family members who have so suffered and are continuing to suffer. So in anything I say, I intend to be as respectful as I possibly can. In particular, I will not employ as a debating scoring point any atrocity, whether committed by Republican or Loyalist terrorists or by the security forces. Secondly, the points I make may well be controversial or unwelcome to some. I challenge what I describe as the comfortable consensus that surrounds the Stormont House Agreement amongst most politicians, many victims groups, the media, and it seems to me, most academics. I also challenge the woeful silence of the legal profession. But again, to the extent I voice criticism, I hope I do so in a respectful way that challenges ideas rather than personally attacking individuals. And finally, why am I treading so gingerly? I suggest that the Northern Ireland society as a whole, and notwithstanding the many thankful years of peace, is still in unresolved trauma from the past decades. We simply have to do our best as the burden of the past continues to overshadow us all. So my title is Stormont House Agreement, a Failed Legacy Project. This is based on the recent paper that Peter Smith QC and I have written, Criminal Justice and the Rule of Law. Our thesis is that insofar as you seek a criminal justice element in legacy, and I think I'm in that camp, at least that criminal justice should not be entirely abandoned. The prospects of any successful truth recovery are very constricted because of the justice requirements to protect all those under investigation. It would be understandable if a victim in great hurt might press that the imperative of truth should trump the justice requirements of anybody identified as a perpetrator. Certainly, politicians feed such assumption with the mantra that the focus of legacy must be victim-centered. Some academics and human rights campaigners assure me that, of course, the justice rights of all will be fully protected, but I've never seen any clear explanation to victims that full truth recovery is practically unobtainable in the criminal justice law context, at least because of the justice requirements of others. So a summary of points from the paper. Firstly, the HIU and exercise of police powers. The draft Stormont House Agreement bill in cumbersome clauses and schedules would have created the Historical Investigations Unit with full police powers, an alternative legacy police force for Northern Ireland, tasked for truth recovery. The HIU would have power in its truth recovery role to make findings identifying perpetrators in its comprehensive family reports, whenever prosecutions could not be taken. Of course, it's vanishingly unlikely now that there will be many prosecutions. So, absent prosecutions, what's the problem with this truth recovery role for the HIU? Very simply put, in a democracy, the police investigate. They don't make the prosecution decisions, and certainly they don't identify alleged perpetrators. These are vital constraints on those who exercise police powers in a democracy. Of course, that's frustrating for victims who may ardently seek full truth recovery. It certainly can't be delivered to them by the police or those like the HIU who would exercise police powers. We must, in the interest of justice in a democratic society, do all we can to counter the danger that the police will abuse their powers. So the vital limitation on police powers to prevent police abuse of power entails that the police or those exercising police powers must not usurp their role in delivery of truth recovery to families. Thus, Keystone Truth Recovery fails and the arch of the agreement collapses. Secondly, then, Article 2 and competing rights. The agreement emphasizes the imperative of effective, independent investigation under Article 2, but no mention of the competing Article 6 fair trial and due process right and the protection of reputation under Article 8. Because the agreement is silent in regard to Article 6 and Article 8, there's a great danger that the HIU investigators, no doubt driven by performance management and scorecard criteria, will believe that their Article 2 duty to be effective is so central to their investigative and truth recovery processes that it trumps the other rights. Thus, victims are misled or mislead themselves that an Article 2 investigative and truth recovery process can deliver the untrammeled truth to them. Thirdly, non-criminal police misconduct. The draft bill contained a web of provisions requiring the HIU to make findings of non-criminal police misconduct against retired police officers where appropriate because of the gravity of the misconduct or exceptional circumstances. Now, the agreement itself did not contain any such proposal, so it's puzzling why this appeared in 2018 in the draft bill. Will someone do investigative research to trace the origins and development of this proposal? Unearth, for instance, the records of the bill team in our Department of Justice between December 2014 and May 2018. Any such finding of non-criminal misconduct against a retired police officer would, of course, tarnish his or her reputation to such an extent as to amount to a disciplinary process or penalty in the form of a reprimand. Surely Article 6, fair trial, and Article 8, protection of reputation, would apply. But the fundamental problem, it seems to me, is the envisaged retrospective application of non-criminal police misconduct censure to the actions or alleged actions, or indeed inactions, of retired police officers committed decades ago. Of course, during their term of service, disciplinary procedures and penalties duly apply to police officers, but on retirement, any police officer becomes a civilian and so ceases to be subject to the disciplinary process. No doubt this is an escape route for any officer from disciplinary sanction for serious misconduct. If the officer retires early before the outcome of any disciplinary procedure, then the process is stopped and the finding of such misconduct cannot be made. This well merits reform of the police disciplinary processes, but any such reform means alteration to the terms of service of police officers. Thus, it should apply only prospectively to cases of alleged misconduct committed after the date of such reform. Adherence to the rule of law requires that while the legislature may change or restrict the rights of individuals, it may not seek to apply such changes retrospectively, such as in the case of this proposal, in an attempt to punish or reprimand alleged misconduct committed prior to the law change. So it's perplexing that the Department of Justice apparently overlooked this principle when they inserted such provisions into the draft bill. Finally then, victim-centred justice. Now there's a clear aim for a criminal justice approach to legacy, as we've discussed, that no one should get away from criminal responsibility for their actions in the decades of sectarian terrorism. And political and public anger here against the government's apparent amnesty intention underscores a general desire still not to abandon the criminal justice element of legacy. But paragraph 31 of the agreement goes further to proclaim that processes dealing with the past should be victim-centred. However, victim-centred does create a problem of principle if respect for the rule of law is to endure. If criminal justice is to remain a central part of the legacy solution, there is a serious but unacknowledged conflict with the victim-centred approach declared in paragraph 31. I need not labour here the grounding principle of criminal justice that the protection of the accused must be paramount to ensure as far as possible that no innocent person should wrongly be found guilty. Is then the insistence on a victim-centred focus anything more than a political platitude? If seriously meant, it puts criminal justice, it seems to me, in grave peril. So my conclusions. Paragraph 21 of the agreement set out the following principles for the approach to the past. 1, promoting reconciliation. 2, upholding the rule of law. 3, acknowledging and addressing the suffering of victims and survivors. 4, facilitating the pursuit of justice and information recovery. 5, is human rights compliant. And 6, balanced, proportionate, transparent, fair and equitable. Collectively then, the principles. But it seems to me the agreement and draft bill fail the principles in the following respects. Number 1, promoting reconciliation. Now, no lawyer should be prescriptive about how reconciliation is to be achieved, but surely anything which promises more than it can deliver, such as truth recovery, or which is perceived to be unfair to any section of the community, such as retired police officers, will hinder rather than promote the process of reconciliation. Number 2, upholding the rule of law. It is contrary to the rule of law to confer on the police or on anyone exercising police powers any role or function of making public identification of guilt or responsibility. It is also contrary to the rule of law, as just discussed, to legislate for a sanction of non-criminal police misconduct to apply retrospectively to retired police officers. 3 and 4 I take together, that's acknowledging and addressing the suffering of victims and survivors and facilitating the pursuit of justice and information recovery. I do so because as a lawyer, I shouldn't presume to prescribe how this suffering can be acknowledged or addressed or information recovery achieved. But certainly from the legal perspective, there is only limited capacity of the criminal justice system to address the suffering of victims and survivors. It is similarly limited because of justice constrictions in any information recovery role. Surely also it is cruelly wrong to purport to promise victims truth and justice when the prospects of achievement are now so sadly minimal. Then, fifthly, human rights compliant. The proposals fail to be human rights compliant in failing to acknowledge and address the Article 6 requirements of fair trial and Article 8 protection of reputation. If it is argued that, of course, these rights will be protected in the operation of the proposals, then the agreement is less than fully candid in failing to explain to victims' families that the Article 6 and Article 8 rights will necessarily limit victims' access to full truth and justice. Then, finally, balanced, proportionate, transparent, fair and equitable. I hope I've set out that the proposals are not balanced because of the excess of power proposed to be conferred on the HIU, not proportionate because of the cumbersome provisions for the operation of the HIU when assessed against the prospects of successful prosecutions, not transparent because of the failure to explain to families the limitations of what can be achieved for them by the way of truth and justice, and not fair and equitable in the discriminatory proposals of the draft bill to single out retired police officers for the censure of non-criminal police misconduct. So, Stormont House Agreement, in my view, failed legacy project and legacy fraud. Thank you.
Thank you very much for that contribution, Neil. We'll return to you, no doubt, after Austin's presentation with some questions and some comments. So now I will hand over to Austin Morgan. Thank you.
Cheryl, thank you very much for the invitation. It is a first for me from Queen's in the last 20 years, which is ironic given that my doctorate was awarded by your university some time ago and not in a subject of law and way before I ever was a professional lawyer. Secondly, I join with Neil in referring to those who are concerned about the debate with legacy. I too understand the degree of suffering, and I don't wish in any way other than to express fellow human sympathy and empathy. The Malone House Group, I agree, is challenging an orthodoxy, and it's important that while we agree on principles, we continue to debate amongst ourselves what some others will consider big issues. And finally, Neil has dealt with human rights in general. I'm going to be much more particular and look only at Article 2, but I accept all his observations on the general human rights frame. I've prepared a 10-page PowerPoint. I cannot go through it in detail. It is a working document which others may use because it refers to cases. So let's begin with slide 1, which is headed "The Dogs in the Street, Article 2 Compliance in Northern Ireland." And my facetious point is that those Ulster canines all bark in unison, Article 2 compliance, every time they look at an expert on television discussing the question of the past. On to slide 2. The context is, of course, the substantive Article 2, the right to life. And here I've laid out some of the important elements, not least the key question of who killed whom, not least my assertion that all terrorist killing is unlawful, but not all state killing is lawful, and the sad case of De Silva against the United Kingdom shows that the state can kill an innocent person and Strasbourg will deem it to be lawful. Now, how has this history been written and remembered? And I say on to slide 3, and these are the cases begun in Strasbourg over the last few years. I've summarized the facts and I've given the case reference. Anyone will see at first blush that these 9 cases are very unrepresentative of the tragedy of the Northern Ireland Troubles. The third case, for example, is brought by the relatives of the 8 IRA members who were killed by the SAS at the Loughgall police station in 1987. These cases are where Strasbourg began in 2001, so Strasbourg never had a chance to seriously address the complexity of the Northern Ireland problem. Slide 4, it is the case that since 2001, Strasbourg has been held to create a new human right, which is the right to a proper investigation of, I think, all killings by state officials. It is not, of course, for the court to rewrite or expand the convention. That is for the members to do. So this assertion that Article 2 procedural is now a freestanding right is constitutionally shaky in terms of the Strasbourg system. The question of investigating the past, because it is the past, is extremely important. And on slide 4, I identify 2 Strasbourg cases, nothing to do with Northern Ireland, where in fact the right to investigate the past, alternatively the duty to investigate the past, was expanded somewhat considerably. I say that as a common lawyer entitled to discuss Strasbourg cases, Sila and Janovich are extremely out on a limb. And one sees it in dissent in Sila of Judges Bratza and his colleague. Judge Bratza was the UK judge at the time, and he thought the international agreement nature of the Strasbourg Convention could not be expanded further and further outside its legal structure. Slide 5. It comes as a surprise when I say in domestic law, that is in domestic UK law, there is good and continuing authority for Article 2 old style or Article 2 procedural to not apply to deaths in Northern Ireland before the 2nd of October 2000. That date is significant because that is when the Human Rights Act entered into force throughout the United Kingdom. For those who want to debate with me, they should look at the 3 cases I've listed here. They should look at how the Supreme Court on the two latter occasions, when it had the power to disapply the original McCare decision from 2004, chose to leave it in place. It is complicated law, but it is the sort of law lawyers argue in court. I turn to slide 6. Now, if I'm wrong about this prohibition on applying Article 2 to Northern Ireland deaths before the 2nd of October 2000, there is another legal limb that pushes Strasbourg back out of our domestic jurisdiction. It's Section 2 of the Human Rights Act. Now, Section 2 has always said that a domestic court must consider Strasbourg jurisprudence. It has never said it is binding. I give 3 Supreme Court cases where the Supreme Court, essentially of its own motion, declined to follow Strasbourg, as if Strasbourg were a domestic appeal court and Strasbourg case law were binding, applying common law rules of precedent. Essentially, the Supreme Court introduced the idea of a judicial debate between UK lawyers and Strasbourg lawyers, and I submit that that is a debate that the UK lawyers executed successfully and respectfully, with the Strasbourg lawyers essentially surrendering and deferring to what they took to be the greater jurisprudential impact of the UK Supreme Court. I turn to slide 7, and this is a concept of retrospection. In practice, Article 2 procedural, this new right is being applied, has been applied since 2001, back to when the Troubles began in the 1960s. So how come actors, for good or ill, in the Troubles are now having hung round their necks legal obligations which did not exist when they were doing their nefarious deeds? In statute law, we do not legislate, Parliament does not legislate retrospectively in essence, though it sometimes does stuff that looks retrospective. In the common law, we have no concept of retrospection, because the common law says that when the Supreme Court changes the common law, it's changing to the correct interpretation. It's not that it's imposing an interpretation on the past. And then finally, even the convention itself is against retrospection, because Article 7 says you cannot punish someone for a wrong which was not legally a wrong when the wrong was done. Therefore, I'm extremely quizzical about the finding of the coroner in the recent Ballymurphy case, a judgment that requires detailed reading and contains much that's extremely interesting. But what I'm troubled by is the finding by coroner, who's bound by colonial law, that there's been a violation of Article 2 on killings that she has examined. Query, does a coroner have the power to make such a finding? I turn to slide 8, and I'm checking the time again. What is an adequate investigation? Strasbourg doesn't say, but certainly the Committee of Ministers seems satisfied with stuff that could be characterized as minimalism. But we have a recent Supreme Court case from 2019 where the late Lord Kerr did all the work, though he was supported by his 4 colleagues. And I quote paragraph 153, who says that the De Silva report, all 841 pages of it, including a lot of original documentation, is not an Article 2 compliant inquiry. But then he goes on, a point not reported in Northern Ireland. That does not mean there now has to be a public inquiry. He says it is for the state to decide, which I say is a correct articulation of the law. So I ask rhetorically, how many De Silva reports will be required to deal with the 3,720 people who lost their lives in a multiplicity of circumstances before Article 2 procedural will be satisfied? I turn to slide 9, and this is the question of the role of victims in our justice system. I make the point that the victims ever since 1998 have been given due recognition to which they're entitled. But our justice system is not one that opens and closes at the say-so of victims. For example, in 1998, the people in Northern Ireland voted in a referendum to let terrorist prisoners out of jail. There was no consultation with any relatives over that issue, and many of those relatives so affected may well bear their sense of grievance as well. One other point, Strasbourg tells us that it doesn't make findings of fact. So explain why it can reach the conclusion that the investigations conducted by the state into at least state killings are themselves inadequate. It seems that Strasbourg is not reacting to inadequacy. Strasbourg is reacting to complaints about injustice from relatives, or I should say some relatives. And finally, slide 10, my final question, and this brings me back to the Malone House Group. I'm indicating what some of us would like to happen, namely Strasbourg should be invited to review its jurisprudence now in its 20th year. That could be done by the Committee of Ministers, not Council of Ministers, as I've written. It could also be done by the nominees to the Parliamentary Assembly through one or other committee. And the question I do end on is, what will the UK government do through its learned ambassador to the Strasbourg court on this idea of Strasbourg itself reviewing whether it has made a positive contribution to dealing with the question of legacy in Northern Ireland, or whether, and I admit freely this is my view, it has made the situation worse than it might have been. Cheryl, I hope I haven't breached your time limit anywhere, and I'm ready, along with Neil, to deal with questions, comments, and just about anything else.
Super, thank you very much, Austin. Thank you, Neil, as well. Before we move to any questions or comments from our audience today, I'd just like to say that I very much welcome the fact that both of you started off your presentations by saying, you know, when we're talking about these sensitive issues around legacy and dealing with the past, we must be very respectful to those who are in the room with us, including in the virtual room, as often we don't know who those people are or what their backgrounds are. And I think that's very good, a very timely and important reminder for these kind of conversations. So I'd now like to open the floor to our participants for any questions for our guests today. Feel free to use the chat bar or to come in over the audio. And of course, don't be shy. Bryce? Oh, I think you're muted, Bryce.
Sorry, can I come in?
Go ahead, please.
Thanks both to Neil and Austin for concise and interesting presentations. To Austin, I would suggest that the Article 2 ship has already sailed, and seeking to reverse Strasbourg's approach to Article 2 at this point, I think, is doomed to failure. But what I would hope would happen was that the court could be persuaded that the kind of approach to legacy which your group and other groups are now suggesting, and lots of other commentators are suggesting, whereby there are no further prosecutions, there is a more truth-focused and victim-centred approach. If all of that is done in the name of reconciliation, etc., would the European Court accept that, even though there may not be the Article 2 investigations that would otherwise be required? That I think is the more interesting point. And to Neil, I would suggest that while there is something in what you say about applying the Stormont House Agreement in a way that affects retired police officers, I think that's really no more harmful or undesirable than the report of any inquiry into anything in the past where the performance or lack of performance by certain individuals is highlighted by the inquiry for good or ill. It's not making a judgment necessarily. And I would agree with you insofar as the HIU shouldn't, or anybody really shouldn't be entitled to label something as misconduct under certain regulations, but the unacceptable behaviour of officials and other individuals, not state officials, but other individuals in the past, can appropriately be commented on by inquiries. And as we know, Maxwell letters are often sent to people who are criticised in inquiry reports. So I'm not totally with you on that, Neil. But thank you again, both.
Could I come in right away on Bryce's point, because I think it's a net one. In fact, Bryce, I do largely agree with you that there's an absolutely proper role for public inquiries that can criticise people, whether public servants or other civilians, for their actions in the past. The RHI inquiry was a prime example of that. But you see, the RHI inquiry had enormous amounts of due process in its fact-finding and public hearings, and everybody would be entitled to know the questions put to them and to answer in full and in public. And as you say, then the Maxwellization process, where they could look at the parts of the report dealing with them. And the HIU had no such process. Somebody commented to me that the civil servants in the Department of Justice were very keen on the HIU because it was a cheap way of doing public inquiries. But sadly, there's no cheap way of doing public inquiries. So I'm quite content if the ultimate decision in one sense was, in theory, that we should have a public inquiry approach to dealing with the past to cover everybody involved. But obviously that becomes totally impracticable in terms of the gross amount of expenditure, time, delay, and resources. So there is a terrible conundrum here between fully and fairly investigating the past and not spending all our resources and time in doing so.
And can I answer Bryce? Yes, Bryce, the ship has sailed, but it has to be crewed and captained, and it may not be robust enough for the high seas and the storms that will come its way. I'll refer to another Strasbourg case. It's Margas, M-A-R-G-A-S, and that is a case arising out of the tragedy of former Yugoslavia. And there a submission was made by some English academic lawyers, I think from Middlesex, that customary international law which of course is not overridden by treaty law, did include a duty upon the state to promote reconciliation after civil strife, that to include the waiving of criminal liability. Now, the argument was put to the court. In this case, the court chose not to endorse that argument, but it did seem to rely upon the proposition that that could continue to apply, but it would not apply in exceptionally abusive cases, which were violations of particular international instruments. In other words, the really bad guys would be dealt with by the state, but the generality of guys, the foot soldiers, and indeed the police men and women and the soldiers, would be allowed to go back to their farms and rebuild a happy and prosperous society. So there is a legal tradition out there. It is a legal tradition that has not been articulated in Northern Ireland in the last 20 years. And indeed, Malone House Group is very late on the scene in terms of offering this alternative, but we seem to have emerged at a crucial time, because it does seem that the current government has been rethinking some fundamentals since the 18th of March 2020.
Thanks very much for those responses there. We have a series of hands up and a comment as well in the chat bar. So in turn, we will go to Kieran McAvoy, Frida Woods, and then Paul Young, and then Conan. So Kieran, if you'd like to come in first.
Thanks, Cheryl, and thanks, Neil and Austin, for your contributions. I wanted to pick up on something Neil touched on in the earlier part of his presentation, and it's around, I think on the Stormont House Agreement more generally, it appears, Neil, you're flogging a dead horse. It sounds to me like the government are heading towards binning the Stormont House Agreement, or coming up with some kind of yellow pack Stormont House Light anyway. Whether or not they think that's going to meet the requirements of Article 2 is a different issue. But my question is around the amnesty question. And so, as you know, the speculation, the driver for this current government, I think, essentially is to ensure that soldiers are not prosecuted. And so my question is, and I'm conscious that not everybody on the call is a lawyer, so maybe we'll not get lost in the legalese. But my question is around your view, Neil, or indeed Austin, on the legality of the suggestion that the executive could reach in, that the Westminster executive could reach into the NI court system and simply stop criminal prosecutions that are before the courts currently. So not ones that might come down the line, but actually cases that are live, in terms of what would be your views on that, in terms of either separation of powers argument, or in terms of the Good Friday Agreement and the devolution of justice, the legality of reaching in to ongoing live criminal prosecutions that are currently before the courts. And secondly, the other suggestion that's in the ether at the moment is that the government may also be thinking about, perhaps in light of the truth that came out of the Ballymurphy inquest, of also reaching into ongoing inquests that are before the courts. So anyway, either if you guys fancy giving that one a lash, and let's not get lost in cases and counter cases, because for non-lawyers that stuff can get a bit boring.
I'll kick off, Kieran. It won't be the Northern Ireland Assembly doing anything, because the Northern Ireland Assembly is heavily dysfunctional. Constitutionally, it doesn't have the power anyway. It'll be the Westminster Parliament. And I think the precedent is a bill in 2005, in the days of Tony Blair, called the Northern Ireland Defences Bill. That was a two-sided amnesty provision based upon the creation of an alternative justice system to take the past out of all the present institutions. That bill failed because everybody said they were against amnesties, but it really failed because Sinn Féin, though it doesn't take its seats at Westminster, had been supporting Tony Blair and Jonathan Powell. And when someone in Derry played the Bloody Sunday card, Sinn Féin took fright, ran, and withdrew its support. Peter Hain, the Secretary of State, then put forward the argument, this bill proceeds, but we're going to treat soldiers equally with terrorists, aka freedom fighters. Sinn Féin refused to do that, and the government withdrew the bill. I think that experience in 2005-06, in very different political circumstances with very different personnel, is the real precedent for what the Northern Ireland office has been up to over the last 15 months. I must indicate this is a personal view of mine, not a Malone House Group view, but I've long taken the view that because our criminal justice system has been successively corrupted, the priority is ending the corruption of the criminal justice system and therefore drawing a line onto the past. And it's a line that would apply both ways.
Yes, if I can come in, Cheryl, I think for full disclosure, I think I was a lawyer in 2005 who opposed that amnesty bill for a whole variety of reasons. So I would certainly be uncomfortable with the prospect of the legislature reaching into the criminal courts or the coronial courts to take away prosecutions or inquests. And also, I would love to find a way of drawing a line under the past that sort of satisfied everybody, but that's simply not achievable. And if you talk of drawing a line, do you include the line to preclude judicial reviews and civil actions and so forth? And the task becomes wrong in most principle and impracticable in operation. Having said that, as Austin says, there's no one Malone House Group view, so others may well have a different view on both of those propositions.
Okay, thank you both. We'll turn to Frida now. Frida Woods has joined us for the seminar today, and Austin, she has a question for you in the chat bar there, or do you want to maybe come in over the audio, Frida?
How do I do it?
That's you.
Just ask the question. Just ask the question?
Go ahead, just go ahead with your question.
Okay, it's a question for Austin Morgan. It's how does derogation of Article 2 impact on legacy? I'm thinking of Margaret Thatcher when she sought derogation under threat to the life of the nation in the Gibraltar incident involving the SAS and Provisional IRA.
Okay. A couple of points. Derogation is a power under the convention, and the member states have not removed it. Therefore, member states can opt out of some provisions of the convention, not all, but it has to be something they do in advance. Second, Gibraltar led to the McCann case in Strasbourg. And what I find significant about that was the first appearance of relatives in 1995, not obviously the people who had been killed in Gibraltar, it was their family members. And Strasbourg chose to give them no damages, give the relatives no damages because of what their family members did. When it came to the lesser procedural Article 2 in 2001, Strasbourg changed its mind and it chose to give damages to the relatives in all of those cases. I see that as jurisprudentially not just inconsistent, but in fact perverse. If the state kills someone, that seems to me to be worse, more grave than the state not conducting a satisfactory investigation, whatever the standard of the investigation is. So, Frida, I wouldn't I wouldn't cite the opinions of prime ministers too deeply in any question of law, because they are the executive branch of government. They're not the law-making branch of government, though, of course, at Westminster, they are jumbled up, and that's what makes our constitution somewhat odd and different from very many others.
Thank you. Thank you.
Thanks very much, Rita. Conan, we have quite a detailed question from you here in the chat bar. Do you want to maybe come in and talk your way through that?
Yeah, no problem. Not sure if you can see me well. Sorry about the informal dress.
Don't worry.
So yeah, so like my thing behind the question was that while the Human Rights Act did not come into effect until 2000, is it also relevant that the UK has been a signatory to the ECHR since 1915? And is there any like contrary domestic law to suggest that the UK should not?
I did read your question, Connor. When the UK signed as one of the first signatories in 1950, that meant nothing in international law or domestic law. When it took effect for the UK in 1953, it meant something in international law, but not in domestic law. And the common law later said that while we can't recognize unincorporated treaties, the executive branch of government in domestic law is circumscribed by treaties that the UK has made abroad, and the convention was being used before 2000 when it came to questions of statutory interpretation. And one now sees the Supreme Court doing the same with other instruments like the rights to the child, which is, I think, a UN multilateral convention, not yet incorporated, but is still being discussed by judges. I was making a much stronger, more critical point about Strasbourg wanting to push back its reach in terms of investigations. And indeed, we had a Supreme Court case concerning Southeast Asia and some British Army killings in 1948. And the Supreme Court tried to go back to 1948, but it could not use the convention to do it, as interpreted by Strasbourg.
Okay, thank you very much, Austin, for that. Do we have any other questions? We are coming up towards close, but there is time for one or two more questions. Perhaps I can take advantage of my position as chair. I have my own question for Neil. And Neil, thank you for your presentation earlier. At the start of your presentation, you mentioned and referred to it throughout your presentation about the importance of a victim-centred approach to dealing with the past. And you discussed that idea of victim centricity in relation to the scope and the limitations of the criminal justice system. And I was wondering if the Malone House Group had given any consideration to a more expansive idea of a victim-centred approach to the past, and what you saw that approach looking like.
Well, as I say, maybe the first thing is the Malone House Group doesn't really sit down and work out a party Stalinist type line. So what I'm saying would be my own views, and Austin is here, and I think Jeff Dudgeon is also participating. There are proposals from that group in Dublin, for instance, for a sort of conditional amnesty approach with reparation, restorative justice, that you would have some sort of information recovery process and then a justice facilitation process. And if that worked, yes, it would be grand, and that would be focused both on the victims and perpetrators, but it would be expected that perpetrators would be willing to join in, and an impartial commission, no doubt chaired by independent international people, because we're not good enough here to do things ourselves, would bring the parties together, and that could maybe take things forward. but will anybody trust those processes if there is still the prospect of prosecution hanging over them, the Boston tapes scenario? So I think there are great difficulties with any of these proposals. Frankly, I think any way one looks, with the best possible will in the world, we are just surrounded by difficulties in this area, and I think we should almost accept that we're in what's called a stuck problem situation, that there is no way to resolve this, and we simply have to find some way of living with it, doing our best for victims in terms of pensions and other initiatives, but not expecting that we can achieve either truth or justice.
Cheryl, could I add that what I don't want to do is draw a line under the past and tell all the people who are victims, we've heard enough, please deal with it yourself. I don't wish the past to be switched off. Before I was a lawyer, I was an historian, therefore to me the past lives through research. And what I really want is, professionally, I want access to government files. There are no terrorist files to get access to, but I do want access to government files. But the minute you go near those, the minute you go near any issue in the past, the question of the threat of civil litigation, of criminal liability arises. One sees in the recent ANC case, which was a failed prosecution, that the soldiers had been involved in the HET process, and they may well have made admissions in the HET process with reference to giving explanations to the families. It was precisely the fact that they'd been involved in that the learned judge ruled that the evidence was inadmissible, and the prosecution had to back off because it had no case. The PSNI is sitting on millions of pages of documents. I have this fantasy of a big warehouse, probably not properly protected, where all the files are held. I want those files released, but they can only be released when there will be nothing that blows up in the face of anyone. So they would, of course, have to be redacted, but I want the files released, and I think it'll be the study of those files which will allow society collectively to adopt a view of the past. It won't allow for the pursuit of individual wrongdoers. It won't allow for the pursuit of police soldiers and politicians. I'm afraid all those people, in my view, get off, but they don't get off if their reputations can be constructed by scholars and independent writers in the future. I'm afraid the past will be written in a rather elongated historical process, with Queen's History Department making a contribution, but we have an awful lot of self-taught and wannabe historians, and history will be written and will speak with many voices. Nothing wrong with that.
Great, thank you very much. That brings us to 2 o'clock. I know some people, including Austin himself, do have to be back to their other commitments. So first of all, thank you very much to Neil and to Austin and to Jeff for putting today's event together, and for the time and commitment that you have given us today. It's certainly been a lot of food for thought. Thank you very much also to all of our contributors. There's been some very thought-provoking questions here, and I imagine that if we had an additional hour, this conversation would continue. So thank you all very much, and I hope to see you all again soon. Bye, everybody.
Bye.
All right.